who will talk about frontiers of tort law, climate change. Mr. Pawa has represented governments, environmental organizations, conservation groups, citizens, businesses, and injured persons in a wide range of legal matters. Many of his cases involve issues of national importance and cutting-edge legal issues. He has extensive trial court experience and has argued numerous appeals. He represented the state of New Hampshire in MTBE litigation. That's the harmful additive that's often found in gasoline. He's represented the state of New Hampshire since 2003, and his case resulted in over $130 million in pre-trial settlements from the nation's largest oil companies and a jury verdict of $236 million against ExxonMobil in 2013. Being from New Jersey, where the Attorney General settled out a case with Exxon for like $5 million, I say, way to go. It's different in New Jersey. In addition to his trial court responsibilities, Mr. Pawa prevailed on 3 appeals in the MTBE litigation in the New Hampshire Supreme Court. He was recognized by Massachusetts as the Lawyer of the Year in 2013 for his MTBE work, and in 2014 he undertook the lobster boat blockade case, where he obtained dismissal of all criminal charges against global warming protesters who used a tiny lobster boat to block a massive coal shipment. He's a regular speaker at law schools and legal symposium, and he has taught environmental law at Boston College Law School. He pioneered the field of global warming litigation, having worked closely with 8 state attorney generals and the city of New York on the first ever global warming tort case. And another little-known fact about Mr. Pawa is he is a killer triathlete, running from spring to fall. You just told me he did the Ironman triathlon in Mount Tremblant in 11 hours and 14 minutes, which is a super fast time if you know triathlons. So I hope you'll extend a warm welcome to Matthew Pawa.
Thank you for that lovely introduction, and I was a half hour slower than he said. It was 11 hours and 44 minutes. I can't take credit for something that too generous. Thank you, Ralph Nader, for having me. It's a privilege and a true honor to be with you. The climate is changing before our eyes. Nearly everywhere we look, we see it happening. In 2007, the Intergovernmental Panel on Climate Change said that climate change was already killing 150,000 people per year. Nonprofit organizations have put the figure higher at more like 400,000 per year and said that by 2030 it could be killing 700,000 people per year. Look around you and you'll see unprecedented downpours and droughts, melting snowpack in the western United States and around the world. It's causing water shortages. Water shortages from melting snowpack will cost western states billions of dollars to re-engineer their water systems to capture water and hold it for longer periods of time because there's less of it and it melts earlier. We have record-breaking heat waves. Wildfires have grown substantially over the last few decades as a result, in part, from global warming. And human migrations have begun. In Syria, perhaps as many as 1.5 million people, farmers, have been displaced by a severe drought linked to global warming and contributing to the social instability in that country, which creates such pressing problems now. Think about that. The Fertile Crescent, where human civilization and agriculture developed, one because of the other, is becoming a parched region displacing farmers because of global warming. Human civilization arose during a relatively stable climate. It's not stable anymore, and in large part, the giant fossil fuel companies are to blame. It's reasonable to ask what they knew about global warming and when they knew it. Thanks to the Los Angeles Times and Inside Climate News, over the last year, there have been a recent series of disclosures about what Exxon in particular knew about global warming and when it knew it. Exxon scientists researched global warming in detail in the late 1970s and early 1980s. The scientists found that the level of CO2, carbon dioxide, the main greenhouse gas, was increasing in the atmosphere. And they said that the overwhelming, their word, overwhelming opinion of scientists was that the source of this problem was the burning of fossil fuels, their main product. They declared, the in-house scientists, in 1982 that, quote, a clear scientific consensus has emerged that a doubling of the carbon dioxide from pre-industrial levels would result in an average global temperature increase of about 3 degrees Celsius, which would be an unprecedented and rapid increase in a mere 100 years. They said that there was, quote, unanimous agreement in the scientific community that a temperature of increase of this magnitude would bring about significant changes in the Earth's climate. They concluded that global warming would cause more rainfall and evaporation, and that, quote, these disturbances in the existing global water distribution balance would have a, quote, dramatic impact on soil moisture and, in turn, on agriculture. And they said there are some potentially catastrophic events that must be considered, such as sea level rise on the order of 5 meters, which, Exxon scientists said, would inundate coastal areas. This was all in the time period 1977 to 1982. And the Exxon scientists gave these conclusions and projections to management, and they issued stark warnings like this one from a 1977 presentation to management. The use of fossil fuels, quote, should not be encouraged, unquote. And man can afford a 5 to 10 year time window to establish what must be done. In 1982, Exxon scientists informed management that mitigation of the greenhouse effect would require major reductions in fossil fuel combustion. Exxon marked the document proprietary and put a memo on it saying it was not to be distributed outside the company. Exxon was not alone. In 1980, the American Petroleum Institute took a dive into the science of global warming. And API, of course, is the trade association for all the major U.S. oil companies. And they were told by a scientist who briefed the American Petroleum Institute that they could expect a 5 degrees Celsius global average temperature rise by 2067, and that this would have, quote, globally catastrophic, unquote, effects. So now we know that oil companies, and Exxon in particular, had some important early knowledge of the problem of global warming. But despite that knowledge, and despite the increasing certainty of the science as the 1990s and the 2000s unfolded, Exxon and other fossil fuel companies undertook a campaign of deception and denial. It's been well documented. Perhaps you've seen the book Merchants of Doubt, or the movie Merchants of Doubt, or perhaps you've read the Union of Concerned Scientists paper called the Climate Deception Dossiers, documenting this campaign of deception and denial about global warming that confused the American people and consumers of Exxon's product and all fossil fuel products about the nature and harms of global warming. It's continued right up till present times. In 2013, Rex Tillerson, the chairman and CEO of Exxon, gave a speech to shareholders in which he implied that the planet was not even warming. In 2013. This was false or misleading. In 2015, he gave another speech to shareholders in which he questioned whether or not the computer models used to project future warming are, quote, lousy, even though the Los Angeles Times reported within the last year that Exxon has been using these same kinds of computer models since the 1980s to protect its own business assets by projecting future sea level rise, for example, and raising its oil platforms. This situation looks to me a lot like the situation with the tobacco companies, paying scientists in a campaign of deception and denial to obfuscate the public about the harms from the product. In fact, some of the same scientists who've been paid over the years by fossil fuel companies to raise questions and deny the impacts and harms and reality of global warming previously worked for tobacco companies to cast doubt on the science of the impact of smoke, cigarette smoke, on human health. It looks a lot like tobacco. And it looks a lot like a tort. All this new information that has come to light in the last year underscores what some of us have been saying for a long time, which is that global warming is a tort, and specifically, it's a public nuisance. Public nuisance is defined simply as an unreasonable interference with rights common to the general public. Global warming harms are classic harms to rights common to the general public, harms to natural resources, harms to a healthy and clean natural environment are classic public nuisance type harms. Now, I said that it has to be an unreasonable interference with rights common to the general public. The courts have made clear that the unreasonable test is not on the unreasonableness of the defendant's behavior, but whether or not the plaintiff should be made to suffer an unreasonable harm, particularly in a case where you're seeking monetary damages. Now, the big fossil fuel corporations want you to believe that they're not responsible because everybody's responsible for global warming and therefore nobody's responsible. But in fact, as a recent study has shown, not everyone is equally responsible. And in fact, the big fossil fuel companies have a disproportionate share of responsibility. Not only do they have special knowledge, some of the evidence that I just outlined for you shows that they had early knowledge and that they then set about to confuse their consumers and shareholders. But in addition, mathematically, if you look at just the top 5 shareholder-owned oil companies in the world, Chevron, ExxonMobil, BP, Shell, and ConocoPhillips, those 5 companies are responsible for about 12 or 13% of all carbon dioxide and methane emissions from the combustion of fossil fuels since 1854, according to peer-reviewed research. So 12 or 13% is not a small amount when you're talking about all of the fossil fuel greenhouse gas emissions in the atmosphere since the 1800s. Effectively, since the time period human beings have been altering the atmosphere. I submit to you that this is a classic case of indivisible injury. Under the law, when multiple polluters contribute to an indivisible harm, for example, hundreds or even thousands of entities, companies that are polluting a river, they're held liable even though their pollution standing alone wouldn't have caused the harm. This is an ancient doctrine, actually, in the law. It goes back to at least the 1880s in the United States in a seminal case called California versus Gold Run Ditch and Mine Company. That was a case where numerous water polluters were contributing to water pollution of a river, and the California Supreme Court, in a case brought by the Attorney General of California, ruled that it was no defense the fact that there were many, many other contributors to the water pollution. And you don't have to pick out whose molecules are whose when you have an indivisible injury. Here, greenhouse gases go up in the atmosphere and they mix together uniformly, and they cause, through this indivisible vector, harm to discrete plaintiffs, victims all over the world, such as farmers, U.S. states, and people who have died of heat death. You might ask yourself, how in the world would you prove causation? Well, there's 2 kinds of causation that are relevant here. One is what we might call generic causation. And generic causation on global warming has been reasonably well established since at least 1995, when the Intergovernmental Panel on Climate Change announced that there is a discernible human impact on the environment. So for a long time now, we've known that in general, human emissions of greenhouse gases cause global warming. In fact, Jim Hansen, a scientist from NASA, famously testified to that effect in 1988, that global warming had arrived. What about specific causation? Could you show that a specific heat wave or a specific mountain range that has lost its snowpack was caused by human emissions of greenhouse gases? And the answer is, it depends on the situation, and scientists have now figured out how to do that. And they're getting better and better at it, and more importantly, they're getting quicker and quicker at it. So when something happens, whether it be a storm or a heat wave or a drought or a wildfire, they very quickly can set to work and they can tell you that the odds were stacked in favor of that event occurring by twofold, threefold, et cetera, based on human emissions of greenhouse gases. Or in some circumstances, they may not be able to reach that conclusion. But specific causation through these detection and attribution studies is now here. So we know who the major culprits are. We know how much they emitted. We know the causation between the emissions of greenhouse gases and the harms. And we know that legally it doesn't matter that there are many other contributors to the harm. I've had the privilege of being involved in two seminal cases on global warming. One was Connecticut versus American Electric Power. The other was Kivalina versus ExxonMobil. In both of these cases, we sought to use the federal common law of public nuisance. And the long and the short of those cases was that the courts, including the U.S. Supreme Court, said that federal common law is not available in these situations. And those of you who have law degrees are familiar with the Erie Doctrine. And the Erie Doctrine basically says that federal common law is a rare exception to the principle that you use the common law or tort law of the states. And so the Clean Air Act, which is what ended up displacing our federal common law claim in those cases, has savings clauses that expressly save state law. And so now it's wide open for the next case to use state law. And there's cases like International Paper versus Ouellette from the U.S. Supreme Court, and a Third Circuit case just decided within the last year or two, Bell versus Cheswick, that quite clearly hold that state law, state tort law under the Clean Air Act is not preempted by the Clean Air Act. Kivalina and Connecticut didn't achieve the objectives that we wanted for our clients, but they did establish several very important legal points. Standing in a tort law case was established by Connecticut versus American Electric Power. The court decided the case on the merits by deciding the question of whether or not the Clean Air Act displaced our federal common law claim. And in so doing, it dropped a footnote finding that there were no problems to the justiciability or jurisdiction of that case. And of course, standing is a jurisdictional question. And so we now have a Supreme Court ruling finding that there's standing to bring a global warming tort case. That was extremely significant. It also established that there's no political question. The defendants have been trying to throw the political question doctrine at these cases for a decade. And the Second Circuit Court of Appeals rejected that in the Connecticut versus American Electric Power Company case, rejected it wholeheartedly. And the U.S. Supreme Court, in dropping that footnote, finding there was justiciability, rejected it implicitly. In addition to the state law of public nuisance, which is now wide open for the next plaintiff to use, the question arises whether or not consumer fraud or securities fraud cases could also be brought. The New York and Massachusetts attorneys general have issued subpoenas to Exxon